Hello everyone. Let's proceed on to the chapter 2, Rights in the Indian Constitution of NCERT Indian Constitution. At first, two case studies are given in which rights of people were exploited. The first case belonged to 1982 Asian Games when a contractor employed a large number of very poor construction workers, and when this came into notice of people, a team of social scientists, when they studied the poor condition, they petitioned the Supreme Court and they argued that their work was was less than the minimum wage and which amounted to forced labor, and as such it was a violation of fundamental right, and the court accepted this plea. And another example of Machal Lalong, he was 23 when he was arrested, and even it was proved that he was mentally unstable. His case did not attracted any hearing, so he remained in judicial custody. So all in all, he spent 54 years of his life awaiting a fair hearing or awaiting a judicial proceedings. So he remained in the judicial custody for 54 years. Now, our constitution gives every citizen the right to life and liberty. This means that every citizen must also have the right to fair and speedy trial. Yes, it is a uh, part of fundamental rights. Then talk about the Bill of Rights. So a democracy must ensure that individuals have certain rights and that the government will always recognize this right. Yes, this is the prerequisite for a sustaining democracy. And these rights, they are mentioned and protected by the Constitution. They are called Bill of Rights. And this Bill of Rights, it prohibits government from acting against the rights of individual and ensure a remedy in case there is a violation of these rights. So, as we have already talked during the lectures of political theory, the rights are important. And our constitution, it has given such fundamental rights from Article 12 to 35. And these are called fundamental rights because they are fundamental to the living, fundamental for the essential for the living of people. And the Constitution has also guaranteed protection against them, that no individual or state authority can encroach upon these rights. Now let's talk about fundamental rights in the Indian Constitution. So during our freedom struggle, the leaders of the freedom movement had realized that the importance of rights and demanded that the British ruler should respect rights of people. And first such attempt to draft a Bill of Rights was made by Motilal Nehru Committee in 1928. So it was the Nehru Committee attempt in 1928. It was the first attempt by the nationalist leader to draft such a constitution. And the word fundamental in fundamental rights, it suggests that these rights are so important that the constitution has separately listed them and made special provisions for their protection. Yes, so the centrality of these rights can be gauged by the protection that is granted to such rights. And one such is during during the encroachment or violation of any of the fundamental rights, a person or an aggrieved, she can or he can directly approach a court, directly approach the Supreme Court. But the other way around, so in other civil and criminal cases or any other for violation of any other legal right, the basic procedure is that you file an FIR in nearby police station, and then the the proceeding takes place from the lower judiciary to higher judiciary. So at first, after filing the FIR, your case is taken up at a lower judicial court, maybe ACGM, and then this ACGM, you can call it local judiciary or district level judiciary. So this local judiciary, it will hear the case, the arguments and counter arguments would be put forward, and a verdict would be delivered. And then if you are not satisfied with this verdict, you can appeal against this verdict in higher courts. So the next station for you or for violation of legal right will be a high court. And even after um, after the whole proceedings are done and a high court verdict is given, and even if you are not settled with that, then only you can approach the Supreme Court. So in ordinary cases, in other ordinary legal rights, for their violation, you need to follow this procedure, you need to follow this hierarchy. But fundamental rights, they have a special place, especially the Article 32, the right to constitutional remedy, which says that if your fundamental right is violated by any individual or by state authority, an aggrieved person can directly approach Supreme Court. So this is the centrality or essentiality or the protection that has been granted to fundamental rights. Fundamental rights are different from other rights. While ordinary rights are protected and enforced by ordinary law, fundamental rights are protected and guaranteed by the Constitution of the country, which means ordinary right may be changed by the legislature by ordinary process of lawmaking. But fundamental right, if there is a need to change them, they can be changed only by amending the Constitution itself. And beside, no organ of government can act in manner that violates them. So, thus is the centrality or the power of fundamental rights that has been granted by the Constitution itself. The judiciary has the power and responsibility to protect the fundamental rights. As I already told you, aggrieved person can approach Supreme Court, and orders of Supreme Court, orders and verdicts of Supreme Courts, they are applicable throughout the length and breadth of India. So any person, aggrieved person, if uh, if he approaches Supreme Court and then verdict is delivered, such verdict will have a force of law. And however, fundamental rights are not absolute and unlimited right. So government can put reasonable restriction on the exercise of fundamental right. So we have already learnt it in the political theory that no right is absolute and no power is absolute in legal jurisprudence. It is because most of the rights, most of the parts and parcel of democracy, they are a product of discussion and deliberation. And discussion and deliberation happen only when uh, many views or multiple views are taken into account. So the constitution or any legal body, it will always take into account multitude of number, and this multitude can be of people, of opinion, of perspective, of rights. So in the same way, if you have right, so has others. So there is a need to put a reasonable restriction on any such right or any such power, so that the absolute right are not given to anybody. And this is a simple explanation. Since if you have right to free speech, you cannot incite violence, you cannot spread hate, you cannot speak anything that comes to your mind. So a reasonable restriction need to be there, so that not only yours but others' right to free speech or other rights, other fundamental rights can be protected. Now comes to right to equality. So right to equality tries to do away with such and other discrimination. So uh, the main purpose of invoking right to equality is to provide equal playing field or equal status to everybody, irrespective of their caste, their place of birth, their sex, their color. So, in short, right to equality does away with any kind of discrimination, and those discrimination which are not justified. Some discriminations are justified, such as I have told you. If your military recruitment test, MRT, military recruitment test, it has certain criteria. It has certain physical and mental criteria for selection. And if you do not meet such criteria and you are kept away from the service, you cannot approach court and you cannot invoke your right to equality, citing that since uh, you have applied for it, but you have kept away from it just for some reasons. So those technicalities, those technical reasons that are not considered. But yes, if the same military recruitment test, if you succeed on other grounds, if you succeed on other technical grounds, but one of the member, he or she debars you because of your caste, your color, your creed, your religion, your place of birth, your language, or any other nonsensical criteria, then you can invoke your right to equality and approach court. But other than that, uh, there should not be any discrimination. And it has mentioned here the right to equality provides for equal access to public places. So all public places, right, like the road, train, um, aeroplanes, all forms of transportation, and all places of entertainment, wells, malls, bathing arts, places of worship. Yes, all such public places, and with the exception of those that charges some premium. Other than that, you will not be debarred from accessing any such uh, public resource, and there cannot be any discrimination on the basis of caste, creed, color, sex, religion, or place of birth. And right to equality also prohibit any discrimination in public employment on any of these criteria. So this example of military recruitment test is already given, and you will not be debarred because of these reasons. Technical reasons may follow, but on these reasons, you you will not be debarred, or you will not be prohibited from joining any service. Next, the issue of practice of untouchability has been given. So this untouchability, it was one of the crudest manifestations of inequality that prevailed in ancient India. And after enactment of constitution, this practice it has been abolished. And a special fundamental right, Article 17, has been devoted to it. Other than that, the constitution, through its right to equality, it has also decided that no title would be conferred on any person other than military and academic ones. And this has been mentioned in Article 18. So no titles, such as those enjoyed by earlier rulers, priests, and people from higher caste and classes, all such titles have been abolished by one sweep of law. Now, an article is given here, Article 16, that talks about affirmative actions. So, during the explanation of equality, during the talks of equality, we have discussed both its positive meaning and the negative one. And positive and negative, it concerns with equal must be treated equally, must be treated equally, which means only equal can be competed against equals. So those who are unequals, they will be they will have equal treatment among themselves. By which I mean, if we talk about two person physically capable and the other is physically incapable. So a person who is able to climb upstairs and the one who is not. So there is a clear distinction between their physical capacity, and the same distinction can be made on the mental ground. So there are various forms of disabilities. The glaringly visible are the physical one, the mental one that will be diagnosed by psychiatrists and psychologists, and the third one will be historical ones, and the fourth one will be social or structural. So these disabilities are there, these disabilities have been there, and because of those criteria, those persons who fall under these categories, physically, mentally, historically and structurally disabled people, they will not be competed against the equal, but they will be counted amongst the unequals. So in order to provide a fair level playing field, in order to provide parity in equality, it would not be bad, it would not be imprudent, sorry, wrong choice of word, it would not be extravagance to provide those unequal with resources, with tools and techniques and mechanisms, so that they have some avenue to be counted among the equal. For example, uh, an example of a government building. So a government building is there, but it is situated on second floor. So those who are physically capable, who are physically fit enough, they can climb those stairs and access the services. But for a physically disabled people, the person who is on wheelchair, so it would be very difficult and almost impossible to climb up to the second floor and access the services, or report your grievances. In that case, if some help is provided to the person with wheelchair, so that the services become accessible to them. So this act, or maybe the options are: first, a lift. A lift is constructed, a lift is installed. Second, a ramp is installed. Third one, a kiosk is open on the ground floor for the disabled people. So all such options are there, and any such initiative is taken, which gives these people a parity with the physically abled one. So this is not injustice, and this is not spatial treatment. And such form of action, it is known as affirmative action. Now, for physically and mentally disabled, some direct action is already taken, and nobody questioned them. But for the historical and the structurally disabled people, such as those who suffer gender stereotypes, those who suffered patriarchal rules, those who suffered the caste inequality and historical untouchability and caste discrimination. So all such people, they are historical and structurally disabled, and for those people, government or the constitution, it has come up with affirmative actions through Article 16, Section 4, in which the constitution has granted government the power to take action, the affirmative action, so that those who are socially and educationally backward, they could be pared down, they could be brought, um, they could be provided with something with which they with which semblance of justice can be seen. So it is not just for appearance of justice, but it is also to give parity, equality to such people who have historically been discriminated. Now let's talk about the list of fundamental rights that we missed. Fundamental right, it comes under part 3. The articles are from article 12 to 35, in which 12 is the index and 35 is the end of such right. Now all these fundamental rights, they can be categorized into these 6 groups. First one is right to equality, which means equality before law, equal protection of law, prohibition on discrimination on ground of religion and any such criteria, equal access to public resources, equality of opportunity in employment, abolition of title and abolition of untouchability. And this will both equality before law and equal protection of law. This is Article 14. Prohibition on discrimination on ground of religion. It is Article 15. And access to public resources also come under 15. Equality of opportunity in employment. It is Article 16. The abolition of titles. It is Article 18. And abolition of untouchability. It is Article 17. Now come to right to freedom of religion. Uh, if we go sequentially, the next will be Article 19, that is right to liberty and personal freedom. So, right to freedom of speech and expression, right to assemble peacefully, right to form association, right to move freely throughout the territory of India, right to reside and settle in any part of India, and right to practice any profession and carry out any occupation, trade, or business, and right to life and liberty, and right of the accused and convicts. So these 6 rights, they come under Article 19. This one, right to life and liberty, this is Article 21, and right of the accused and convicts, it is Article 20. And all of these rights, 19, 20, and 21, they can be clubbed into right to life and right to liberty and personal freedom. And you can see that the constitution, it has bestowed upon us a whole range of rights, a whole range of personal freedom, so that and even all such rights are fundamental rights which are protected by the law itself. So the constitution, it has benevolently provided us with such rights so that we can live a minimum standard of life. And let me explain a few things which may not make sense. Right to assemble peacefully and form association, both of which means the right to protest. So this comes under the freedom of speech and expression. In any legal, constitutional, and democratic design, people have the right to exercise their vote, and people have the right to share their opinion. And you, it is clearly about money, since you are paying taxes, and your taxes are being levied and appropriated by the state executives uh, for for the for the governance purpose, and one of which is your own benefit. And now two scenarios can be there. First, the appropriation of amount is not proper, and second, the state authority, it it resort to some wrong action, some violations, and those violations can be constitutional or moral or legal. So in such a case, people, they have the right to protest. They have right to expose such wrongdoings, or they have right to express their opinion. And other than that, people may have some demands. People can come up with situation in which um, they need the government to act on certain matters. And in such a case, the aggrieved people, or the people with common agenda, they can come together, and uh, and they can form association or assemblies. And such assembly, they it need to be peaceful, because no absolute right is given. So violence will not be tolerated, but a peaceful association or peaceful formation of assembly, peaceful protests, they are these rights are given by the constitution. And next, any individual can move throughout the territory of India. Yes, this movement, it can be for trade, for business, for settling down, for recreation, or for tourism purposes. And even here, some restrictions are there, such as uh, there are some area where you cannot trespass, one of which is private property. Other such areas, such as military cantonments, or any such area that need authorizations. So such areas that are not open for you, private properties are not open for you, and there are many such pristine areas, such as biodiversity hotspots, some national parks, in which your movement will be restricted. Some dangerous threat prone area, the, uh, those will be the area where your movement will not be allowed. So other than such technical restrictions, you are free to move out throughout the territory of India, and you can also reside and settle in any part of India. Next, you can practice any profession of or any occupation. So right, it may seem useless here, it may seem strange here, because uh, in present circumstances, or in the present year, in 2024, this right is taken for granted. And at present, nobody is stopping you from carrying out any any activity of your choice, whether it is recreational activity, a professional activity, or an occupational or trade related activity. So you may think why this provision is there, but before the enactment of constitution, the the ancient society, it favored caste hierarchies and caste based occupations. So right now, you may have a lot of freedom regarding the choice of your occupation. Your father may run a shop, your father may run a hotel or business, your father may be in government service or in a private management, and you are free to carry out, or you are free to undertake any economic activity. But before the enactment of constitution, there was a time when caste-based occupation uh, were practiced, and mobilization or deviation from such occupations, it was not tolerated. So what it meant, if you were born as a carpenter, your family worked as a carpenter, in timber related activity, so you could only undertake that work. If you were born as a cobbler, you could only um, you could only make shoes. If you were born in a weaver family, you could only weave clothes. If your family that belonged to farming of farmers, you could only undertake agriculture based activities. So such was the restriction during social restrictions during that time. And for that reason, the the Constitution of Independent India, it had to provide provisions, and that too in fundamental rights, so that if any group of people, if they stood up against any such deviation from caste-based occupations, an action could be taken against them. Next comes the right to life and liberty, the most dynamic law, and the right of accused and convicts. So this law, this particular section, Article 20, it needs some explanation. So right of accused. So at first, the law recognizes that everybody is innocent until proven guilty. So no matter how a person is arrested and what circumstances he is arrested, unless he is proven guilty in a court of law, he is innocent. So that's why they are called accused. And then comes the convicts. Convicts are those who are proven guilty. So it is between innocent and guilty. Accused are innocent and convicts are guilty. Now, the Constitution has granted the rights to both accused and convicts. So at first, mm, no court of law or no circumstantial evidence or no um, nothing will prove, nothing will accuse a person, nothing will convict a person other than by the procedure established by law. Yes, that's the best summary possible. Yes, nobody can be accused or nobody can be proven guilty unless they are proven guilty by the court of law. They are proven guilty by the procedures established by law. And one such procedure is that, uh, let me give you a background why these provisions are there. So during the British India, when the nationalist leaders, they were demonstrating and protesting against the atrocities of the British, so they were arrested in an arbitrary manner. They could be arrested anytime, anywhere, without any reason, and with bogus charges. So many of the nationalist leaders, they have spent a lot of their time, lot of the precious years in jails. So to prevent the future generation of leaders from exercising such an atrocity, our freedom fighters or nationalist leaders, the members of Constituent Assembly, they installed this provision in the fundamental rights itself, so that no innocent could be jailed on the bogus charges. So the right is that, first, if any police authority, uh, if police arrest anybody, that arrest should be coupled by the presentation of the accused to the local and nearest magistrate within 24 hours. So even if you have been arrested for wrong reasons, even if your arrest is a political one, even if you are arrested because you stood up against the wrongdoing of government and or some other reason, you are innocent but arrested. So the legal recourse is there, which is written in the constitution itself, that you would be presented before a local magistrate within 24 hours, and the local magistrate would decide whether the arrest it is lawful or arbitrary. So this is the first recourse under which you would not be jailed for some made up charges or some bogus charges. And then after the arrest, even if the local magistrate he send you to judicial custody, even after that you have a right for representation. That is, you can be represented by a lawyer of your choice, and you can even present your argument on your own behalf. If you don't need a lawyer, you can present your own argument. And third, your case would be heard. The Constitution, it has given the right to free and fair trial. But, but you may ask that when we started this chapter, we heard about that person who was arrested in when he was 23 and he was released when he was 77. So he spent 54 years of his life just awaiting a free and fair trial or just awaiting a hearing. So how is that possible that Constitution has guaranteed hearing to all people, but still a person has spent 54 years of his life just so that the court hears him and um, bail him out. This this reason is because of two uh, two lacuna. The first one is population, and the second one is resources. So the problem with Indian judicial proceeding is that first we are too many, around 130 to 140 million people, and uh, because of that there is a backlog of cases. And second, the resources that are available with the government that are limited. Government cannot have a lot of functioning branches of judiciary all over India, because every branch, every such activity, it would cost a lot on exchequer to have those many judges, to have uh, uh, an infrastructure which can house the judges and their subsidiaries. So this to install such a machinery, we are resource limited, and the population it is already increasing at a rapid pace, and which creates a backlog. And because of that backlog and the presence of other practicality, a person who is poor, a person who has no other legal or financial avenue. So it is a sad truth that many poor people, if they end up in jail just for judicial custody, many of them spent years before they get a chance for their first hearing. This is a sad reality, but it is there. Next comes the right to freedom of religion. So first one is freedom of conscience and profession. Everybody can have a freedom of practice their own religion, freedom to manage religious affairs, and freedom to give religious instruction in certain institution. Such rights have been given to religious section, that they can profess a religion of their choice, and mm, they can provide instruction or religious teaching in the institutions of their choice. So for that matter, many madrasas and many mutt gurudwaras, they are working, and uh, many pupils are getting educated or getting instructed by them. Then comes right against exploitation. So this Article 23 and 24. So both of them prohibits. The first one prohibit forced labor, and the second one, they prohibit employment of children in hazardous jobs. Then comes cultural and educational rights of minority. So language and culture of minority is given protection by the constitution, and the minorities have been given the right to establish educational institution of their choice. And all these rights, they come from art come under article 25 to 30. Then comes the right to constitutional remedy, that is article 32, in which if any of your fundamental right is violated, you can directly approach a court. And this has been listed in article 32. Next, the equality of opportunity means that all sections of society enjoy equal opportunities, and the constitution clarifies that government can implement social scheme and measures. This is what I have explained about affirmative action, that constitution has given the government the both authority and the directive to work for the welfare of such socially and educationally backward class. And reservation is a form of affirmative action which provide employment percentage of employment to such socially and educationally backward classes. So that's all for now. Kindly subscribe the channel. Let's proceed on to part 2 tomorrow. Thank you.